I'm disability lawyer David Brannon, founder here at Resolute Legal. In this video, I'm going to explain to you the two types of hearings that you can get at the Social Security Tribunal for a CPP disability case. After watching this video, you will know the two types of hearings that you can get there at that tribunal, the differences between them, and what makes sense and what you should expect. Now, if you like this video, please hit that like button. We really enjoy those likes. Leave us your comments. Don't forget to subscribe and hit that bell notification. We get these videos out a few times a week. So what are the differences between the two types of hearings that you can get at the Social Security Tribunal? Now, a hearing means that you appear before the tribunal to make submissions, appear before one of their decision makers. They serve in the roles of a judge and adjudicator. There are two types of hearings that you can get before these people, and it's important to know the differences between these two types of hearing. So the first thing to know is that the Social Security Tribunal is not part of Service Canada. Yes, it is run by the government, the same government that runs Service Canada, but they are separate departments. They're separate, well, not really separate departments even, but they're separate entities. They are kept off to the side. There's no mingling of the people. They are set up to be independent from Service Canada, and they are. So there's no worry that this is the same Service Canada people that have been denying your CPP disability. The tribunal is separate. I think it's important to just say that up front. Now, there are two types of hearings when you get to the tribunal. To get to the tribunal, you must have done your reconsideration appeal with Service Canada and got a denial. Once you get that denial, your next level of appeal is at the Social Security Tribunal. And that's where these two types of hearings come in. The first hearing, and you don't really have a choice, it's mandatory. The first type of hearing is with the General Division, and all appeals start here. You need to have your reconsideration decision in order to even get there. And this is what I call a true hearing. When I talk about your hearing at the Social Security Tribunal, what I'm referring to is the hearing you get, the first one, at the General Division. This is what people expect a hearing to be. It's like a mini trial. You get to give your verbal testimony, you get to tell your story, you get to present your documents, the judge will listen to you, they'll ask questions back, and it's your chance to tell your story, okay? It's your final chance to tell your story. That's the thing you need to keep in mind here, but it is your chance, and this is the most important appeal of your whole case. If you've made it this far, this first hearing at the Social Security Tribunal is the most important. If you get denied at this hearing, so the judge issues their decision, you get it, a few months after the hearing and it's denied. Yes, there is a second level of appeal within the Social Security Tribunal. It's called the Appeals Division. It can be kind of confusing. The General Division is the first hearing, which is an actual hearing. The second one is an appeal, and it's at the Appeal Division. Now, you don't have a right to go to the Appeal Division. You can apply to have them consider your appeal. So you almost have to apply to have an appeal. Now, the important thing to know is that at the Appeal Division, you are not getting a new hearing. This is a very different type of hearing. This is not a place where you're going to get to tell your story again. In fact, you're not allowed to do any of that. The only things you can do at this next level, it's a very narrow type of appeal. You can only appeal on 3 grounds. But one, you have to show that somehow the hearing below failed to follow the laws and rules of natural justice and fairness. That is extremely hard and basically almost impossible that you're going to prove that. Unless you just have some rogue judge who doesn't care about their job, then this is very unlikely that you're going to have that happen. Fairness just means that you were given an opportunity to speak, to present your case, that these kinds of basic things, that you got a hearing. The second one is that the judge below made an error of law. Now, a lot of people think, well, they found against me. I'm obviously disabled, so it has to be an error of law. No, that's not really how it works. An error of law means they applied the wrong legal principles or the right legal principles and just did it wrong. You can disagree with them, but they may have not made any actual errors of law. As if they're citing certain cases that stand for certain principles, and then they apply those principles to your case, then they're not making errors of law, even if they find against you and you disagree. Very hard to overturn on errors of law. I mean, we have done it from time to time, but very difficult. And because most of these judges are very professional, that most of them have a legal background, they get a lot of training. Very hard. You're going to find errors of law in here, but I guess it's always possible, especially if it's something that doesn't come up all the time. The third area that you can appeal on is that they made an error of fact, and this is the one people seize on. But what's important to know, it just can't be an error of fact. It has to be that they made an error of fact in a perverse or capricious manner without regard to the material before it. Now, that is a legal term. It has a certain legal meaning. It means that they just can't make a factual error. It has to be so bad that it would affect the outcome and that it was just, so because people will say, oh, look, they got my name wrong. They got the date wrong. None of those things matter. It has to go right to the heart of the matter and be clearly factually wrong. It can't be that they've interpreted it. So, for example, you can't say, well, they made a finding that that I'm not disabled, that's an error of fact. No, it can't be something like that. It has to be that, like the cases where we've been successful on this, for one I can remember off the top of my head, was the adjudicator said there was no medical professional who said that this applicant was disabled before the end of the minimum qualifying period. Okay, well, they shouldn't have wrote that because there was actually a report in the file. Okay, it has to be in the file, but there was a report before them. It was actually only a few months before, and they just overlooked it, where a doctor said that the client was disabled, and we got it overturned on that basis. Okay, it got sent back for a new trial. So, but that's rare that they're going to make that kind of mistake. But that was perverse because there was actually a report in there, exactly the opposite of what they said. Now, if that judge had said, I've reviewed the report from Dr. So-and-so that came a few months before the MQP, but I still find that this person is not disabled, we would have been done. There would have been nothing to appeal. You can't appeal something like that just because they disagree with the doctor. The fact that they overlooked the report completely and said there was no such report, that met the standard of an error of fact, okay? You need to focus 100% of your efforts on the first hearing. This second hearing is really difficult to do. In fact, we won't even represent people in these hearings unless we've handled the first hearing. Because without the proper foundation there and all the facts before them, you really are going to be an uphill battle to try to win on the second hearing. Because often the reason that you've been denied is you forgot to put in proper information, you didn't present this thing properly, and that's kind of where it ends up. It's easy to get into the routine that you're doing these appeals and you're just doing another one, you're getting more information, well, we'll try another appeal. That is not how it works. Like up until the point when you get to the Social Security Tribunal, you can kind of be loose with it. Just, well, we'll do it again. We'll get more information the next time. That stops at the first hearing at the Social Security Tribunal. So that is when you should, at the very least, get a legal advice or from someone who is extremely experienced with these appeals on what should I be doing? What am I missing here? The thing is, if you have gotten this far, the approach you're using is not working, okay? So you can't just continue to use your same approach that you've used the whole way along. You got to really step back and evaluate your situation and say, what's going on here? What can I do differently that I can get a different decision at the Social Security Tribunal? You can't just keep playing the same thing and doing the same thing you've been doing all along. You got to step back and see what's different. Sometimes you need to have an outsider look at you to help, an outsider review your situation to try to help you see what you may not be able to see yourself, okay? It's always hard to be critical of your own situation. That applies to lawyers. That applies to anybody. It's very hard to be objective about your own situation. And usually where the blind spots here are is that you're not addressing the key issues that are red flags for the decision maker. You don't really want to be getting into doing the second level of appeal. You can do it, but most people who try to do that are just going to get denied because you're not going to, you're only allowed to do it on those three reasons that I discussed. So again, most people are just going to say they disagree with it, but it's very technical at that next level. All right, that's all for now. If you have any questions, please leave them in the comments below. We look forward to seeing you next time.